Kyle Rittenhouse took the witness stand today in his homicide trial to give his account of what happened the night he shot 3 people in Kenosha, Wisconsin. He was 17 years old on that night of unrest in the summer of 2020. 2 of the people he shot died. Rittenhouse's defense team says he feared for his life and was acting in self-defense. The judge called for a break when he got emotional on the stand while walking lawyers through what led up to the shooting.
I was cornered from in front of me with Mr. Zeminski, and there were there were 3 people right there.
So I want to bring in CBS News legal contributor and Loyola Law School professor Jessica Levinson now. Hi, Jessica. First off, why did the defense decide to call Rittenhouse to the stand? That's usually, or it's not a typical strategy, correct? So why is it their strategy, and do you think it's working so far?
So I would say it's not atypical in a case where it all centers around self-defense. The facts in this case really are not in dispute. We have video evidence. We have a lot of testimony. We know what happened. For the jury, it's up to them to decide if what happened is criminal or reasonable. Reasonable in this case being, did Rittenhouse act with self-defense, in self-defense? And that depends in part on his state of mind, on his experience. So it is true in a lot of other cases, you don't call a criminal defendant, but I think what a lot of people will see, what a lot of defense attorneys will expect is that the jurors will say, if this whole case hinged on his self-defense and his idea that he had to use deadly force, then why aren't we hearing from him? So I think they have to close that loop and really give the jurors the explanation here.
And so looking at the prosecution's, cross-examination, what was the strategy you saw there? And do you believe that the prosecutor was effective in opening holes in the defense's argument?
So I think the prosecution's strategy here is really to try and widen out the time frame. So the defense is going to say, okay, in this snapshot, then Rittenhouse feared for his life. He had to act this way. In this snapshot, he feared for his life. He had to act this way. The prosecution is going to try and say, let's look at a broader snapshot here. Let's look at all of the decisions that Rittenhouse made along the way to put him in this place. Let's look at all the decisions that he failed to make, all of the kind of off-ramps so that he wouldn't have been in this situation where violence was escalated, where he ended up killing 2 people and injuring 1. Now, you asked me about is it effective? Obviously, social media is not a focus group, but I looked quickly on social media, and I will say people's responses are so divided on this. I'm so curious to see if somebody's in the room, what the jurors are thinking at this point. But again, the prosecution trying to give a really wide view, tell the jurors there are so many points along the way that we could have avoided these tragedies.
Well, points along the way where he actually chose to ignore or break the law before he got to that point, correct?
Right, exactly. So they talked about, everything from why did you decide to go? Why did you decide to purchase that weapon when you don't have the right to purchase that weapon as a minor? Why did you decide not to go home when there was a curfew? You knew you needed to go home. So I think the prosecution is really saying, you set this in motion, so you cannot now claim self-defense. And that is part of Wisconsin's law, which is if you're the aggressor, you can't claim self-defense. But a lot of it depends on which time frame the jury thinks is key here.
Okay, so what part of Rittenhouse's testimony, after listening to it, do you think will have the biggest impact on his case? And did you hear anything from him that you think could make or break this?
So I think that for Rittenhouse, it really has to be, do the jurors buy the story? And I hate to kind of put it so bluntly, and obviously this is an emotionally charged case. There's so much in the background of this case. It's another case in our criminal justice system where more hinges on it, in fact, than is fair in a way. But if the jury says, you know what, if I were in his position, I would have done the same thing, then there's no then he's not found guilty in this case. Then they say this is self-defense. But if the jury says this is a guy who set all of this in action, there's so many things that he could have done that would not have resulted in 2 deaths, I'm not buying this, then he goes to jail, then he goes to prison.
Right. And, what do you think of that break in the testimony over the prosecutor's, line of questioning and bringing up Rittenhouse's actions before the shooting and verbal threats he has made? The judge is saying he can't use that line of questioning. So explain that. What rules were made by the judge earlier that caused, a little bit of this argument or disagreement, shall we say, between the judge and prosecutor?
Yeah, we found the judge really screaming at the prosecutor outside of the jury when the jury went somewhere else. And the judge said, essentially, we already in pre-trial decided what evidence comes in and what evidence doesn't. And that's typical in every criminal case. What will happen is the prosecution will want to bring in more evidence to indicate, for instance, this isn't a one-off for Rittenhouse, that he has the type of character which would indicate that he would engage in these criminal acts. The judge said, I very specifically told you, do not go into these areas. Basically, don't open the door, don't walk into that room. You walked into that room. I can't believe you did that. And if you want to anger a judge, going against their pretrial motions is a great way to do it. So look, it's an issue that the prosecution could bring up on appeal. They could say, we meet if they lose. We needed to be able to bring that evidence. But at that point, it sounded like they were transgressing what the judge had said was admissible.
Jessica Levinson, thank you so much for joining us. As always, we appreciate your legal expertise.
Thank you.